Most drivers have no idea what happens the second they're pulled over for a DUI. One moment, you're driving home, and the next, flashing lights in your rearview mirror, a uniform at your window, and a single wrong word or movement could land you in serious legal trouble. Fines, arrests, or even a criminal record. It doesn't have to happen that way. There are 5 legal rights that every driver in the US needs to know. Rights that can completely change the outcome of a DUI stop, protect your freedom, and give you control of the situation. And in this video, I'm breaking down each one step by step with real legal insight and examples you won't hear anywhere else. Number 1. Refuse field sobriety tests. When an officer pulls you over for a suspected DUI, one of the first things they'll often say is step out of the vehicle and perform a few quick tests. These are called field sobriety tests, and they include things like walking heel to toe, balancing on one leg, or following a pen or flashlight with your eyes. They sound simple, but they're not designed to help you. They're designed to create evidence the officer can later use to justify an arrest. What most drivers don't realize is that in almost every US state, you're not legally required to perform these tests. Under the 4th Amendment of the US Constitution, which protects you against unreasonable searches and seizures, you have the right to refuse voluntary roadside tests. Here's why that matters. These tests are inherently subjective. Even a completely sober person can fail based on the officer's opinion alone. Maybe you were nervous, tired, wearing slippery shoes, or standing on uneven pavement. The officer is already looking for signs of impairment, so any tiny mistake becomes evidence. Once that happens, you're likely getting arrested, even if you haven't had a drop to drink. Politely refusing takes that weapon out of their hands. The right way to handle it is calm and respectful. Officer, I'm choosing not to perform any field sobriety tests. You're not arguing, you're simply exercising your legal rights. Now, here's a real example that shows why this matters. In State v. Meckler, Texas 2004, the driver was arrested for DUI after allegedly failing field sobriety tests. But in court, his attorney challenged the officer's methods and argued that the tests were unreliable and administered incorrectly. The Texas Court of Criminal Appeals agreed that the tests are not scientifically reliable indicators of intoxication, and the case helped establish that performance on these tests can't be treated as conclusive proof of guilt. Cases like this show that refusing these tests isn't about hiding something, it's about protecting yourself from unfair evidence. So remember this. Field sobriety tests are voluntary. You have a constitutional right to decline them. Doing so doesn't make you guilty, it protects you from being misjudged. In a DUI stop, saying no politely and legally might be the smartest move you ever make. Number 2. Politely refuse a vehicle search. When you're pulled over for a suspected DUI, one of the most common tricks officers use is asking, "Mind if I take a quick look inside your car?" It sounds casual, almost harmless, but that single question can change everything. What most drivers don't realize is that unless police have a warrant or probable cause, you have every legal right to say no. Under the 4th Amendment of the US Constitution, you are protected from unreasonable searches and seizures. That means an officer cannot legally search your vehicle without one of 3 things: your consent, visible evidence of a crime, like an open bottle or drugs in plain sight, or probable cause backed by specific facts. Here's the trap. Officers are trained to make requests sound routine, so people agree without thinking. But the moment you say, sure, you've legally given them permission, and anything they find can be used against you in court. The smart move is to stay polite but firm. You don't need to argue or get defensive. A calm line like, "Officer, I do not consent to any searches," is enough. It clearly asserts your rights without escalating the situation. And the beauty of that phrase, it's legally powerful. Courts recognize it as a valid refusal. Now, let's look at a real-life example that proves how crucial this is. In United States v. Jones, 2012, police attached a GPS tracker to a suspect's car without a warrant. The Supreme Court ruled that doing so violated the 4th Amendment, reaffirming that any search or intrusion into a vehicle without proper legal authority is unconstitutional. While that case involved technology, the same principle applies to physical searches. Your car is private property, and officers can't dig through it without legal grounds. Here's another case closer to DUI law. In People v. Evans, Illinois, 2013, officers searched a driver's car after a DUI stop, claiming to smell alcohol. The court later ruled the search invalid because the smell alone wasn't strong enough probable cause. The evidence found inside, which included open containers, was thrown out and the charges were dropped. The takeaway is never give away your rights just because someone in uniform asks nicely. Saying no isn't confrontational, it's constitutional. A single sentence, "I don't consent to a search," can be the line that protects your privacy, your record, and your future. Number 3. Record the interaction. Legally. When those red and blue lights flash behind you, you pull over, roll down your window, and an officer walks up with a flashlight in your face. It's in that moment that your best protection might not be your memory, it's your camera. Recording a police stop is one of the smartest, most legal things you can do during a DUI encounter. Why? Because in the United States, you have a constitutional right to record public officials, including police officers, while they're performing their duties, as long as you're not interfering. That right is protected under the First Amendment. But here's where it gets tricky. Some states have two-party consent laws for audio recording, meaning everyone being recorded must agree. In those states, secretly recording audio could cause legal issues. However, video recordings made openly, especially from a dash cam, phone mount, or body camera, are fully legal across the country. Most major court decisions now affirm your right to record law enforcement in public spaces. This right became crystal clear in the landmark case Glick v. Conifer, 2011. Simon Glick was recording Boston police officers who were arresting someone in public. The officers arrested him for illegal recording. But the First Circuit Court of Appeals ruled in Glick's favor, saying citizens have a clearly established right to record police in public under the First Amendment. That case set a national precedent, and today it protects your right to record traffic stops, DUI encounters, or any police interaction. Here's how to use that right the right way. If you're stopped, calmly inform the officer, "Officer, I'm recording for my own safety." Keep your phone in a visible mount or hold it where they can see it. Don't make sudden movements. You can also use a dash cam that records automatically when your car starts. That's one of the safest options. And here's why it's so important. Video evidence has saved countless innocent drivers. There have been cases where police claimed a driver was slurring or acting drunk, but body cam or dash cam footage showed they were calm and coherent. That kind of evidence can completely change a case, often leading to charges being reduced or dropped. Recording your interaction isn't about confrontation, it's about protection. When the law meets your rights, video is your shield. It's hard to twist the truth when the camera doesn't lie. Number 4, request a lawyer immediately if arrested. If you're ever arrested for a suspected DUI, the next few minutes are some of the most important of your life. What you say or don't say can decide whether you walk free or face months of legal trouble. The most powerful words you can use at that moment are simple. I want a lawyer. Under the Fifth and Sixth Amendments to the U.S. Constitution, you have the absolute right to remain silent and the right to an attorney. That means once you're placed under arrest, you don't have to answer any questions about where you were, what you drank, or what you did. It doesn't matter if officers tell you it'll go easier if you just cooperate. They're trained to gather evidence, not to help you. Every word you say, every explanation you give can and will be used against you in court. The best move is to clearly state, "Officer, I'm invoking my right to remain silent and I want to speak with my lawyer." Once you say that, police are legally required to stop questioning you until your attorney is present. This is backed by one of the most famous Supreme Court cases in American history, Miranda v. Arizona, 1966. In that case, Ernesto Miranda confessed to a crime after intense questioning without being told of his rights. The Supreme Court ruled that his confession was inadmissible because he hadn't been informed of his constitutional protections. That ruling created the Miranda warning, the line you hear in every cop show. You have the right to remain silent. Anything you say can and will be used against you in a court of law. You have the right to an attorney. But here's the part most people miss. Those rights only protect you if you clearly assert them.
Staying silent without saying you're invoking your rights isn't enough. You have to say the words, calmly, clearly, and respectfully. After that, don't answer questions, don't make small talk, and don't explain yourself. Just wait for your lawyer. There are countless real-world examples of this saving people. In People v. Tom, California 2014, a driver arrested for DUI made several statements after being read his rights, and those statements were later used against him. The court emphasized that unless a person explicitly invokes their right to counsel, police questioning can legally continue. In other words, silence isn't enough. Your invocation has to be clear. So remember this. In that high-stress moment, you don't need to argue, justify, or explain anything. The smartest move isn't talking your way out, it's lawyering your way out. Because once you say, "I want a lawyer," the law itself steps in to protect you.
Number 5. Challenge breath or blood tests. If you're arrested for a DUI, one of the first things officers will do is ask you to take a breath, blood, or sometimes urine test to measure your blood alcohol content. What most people don't realize is this part of the process is legally complicated. You've entered the world of implied consent laws, which exist in every U.S. state. Here's what that means. When you got your driver's license, you automatically agreed, or implied consented, to take a chemical test if you're lawfully arrested for DUI. Refusing a post-arrest test can lead to license suspension or even additional penalties, even if you're later found not guilty in court. But that doesn't mean you have no power. The key is to understand the difference between a preliminary roadside test and an official chemical test after arrest. Before you're arrested, you can legally refuse handheld breath tests, often called preliminary breath tests or PBTs. These are voluntary in most states. Officers might pressure you, but you can say, "I'm not consenting to any roadside breath test." After you're formally arrested, the official breath or blood test becomes a different story. That's when implied consent kicks in. Now here's where things get interesting, and where courts have sided with drivers. In Missouri v. McNeely, 2013, the U.S. Supreme Court ruled that police cannot forcibly take a blood sample without a warrant unless there's an emergency. This case changed DUI law nationwide. Before that, some states let officers draw blood immediately after arrest. But the court made it clear, your body is protected by the Fourth Amendment against unreasonable searches. That means if cops demand a blood test without a warrant and without your consent, it's illegal. And there's more. In Birchfield v. North Dakota, 2016, the Supreme Court drew a sharp line. Breath tests can be required under implied consent laws, but blood tests require a warrant. So if an officer threatens to charge you for refusing a warrantless blood draw, they're violating your constitutional rights. So what should you do? If you're asked to take a test after you're arrested, you can politely ask, "Officer, do you have a warrant for this test?" If they say no, and it's a blood test, you're on solid legal ground to refuse. But always remember, refusing may trigger automatic penalties, so you'll want your lawyer to challenge the legality of that refusal later. Many DUI cases have been thrown out because officers mishandled chemical tests or violated implied consent rules. By knowing the line between a voluntary roadside test and a post-arrest chemical test, and by asking whether there's a warrant, you're doing exactly what the Constitution protects, asserting your rights without resistance. In short, when it comes to DUI tests, don't panic, don't guess. Ask for the warrant, know your rights, and let your lawyer handle the rest. Traffic stops, DUI arrests, and police encounters can happen to anyone, and one wrong move can cost you your freedom. On this channel, I break down real U.S. laws, your legal rights, and what you can do in these situations to protect yourself. If you want to stay informed, make smart decisions, and avoid common mistakes most drivers make, hit subscribe and turn on notifications. Knowing your rights isn't just smart, it can save you from serious trouble.